Good evening.
Hi.
How are you?
Good. I
Good.
just put a, I don't know why I just put a cracker in my mouth.
That's okay. Oh, well,
Did you have a good weekend?
yes, it was very nice. How was yours?
It was good.
Good.
Yeah.
Did you guys do anything?
I can't even remember what I did yesterday. I don't remember what we did.
Oh, that's
I
okay.
know it was good. I can't even think right now. My brain's fried.
Oh, man. Well, we'll go ahead and get started.
Okay.
Here we go. All right, ready? Town, report, around, reason, myself, found, bring, along, six, mind, remind, statement, saw, read, leave, special, payment, for, does, nice, heard, called, following, left, summer, seem, interested, either, price, reference, used, didn't, probably, coming, general, show, meeting, bank, request, afternoon, question, meet, end, position, subject, address, least, full, 10, asked, affect, effect, according, stated, thanks, factory, Tuesday. All right. Here are some medical words. Ready? Liver damage, symptom of syphilis, blotchy complexion, watery eyes, cancer in remission, high blood pressure, mastectomy surgery, pharmaceuticals flourished, severe headache, calls fracture, obviously broken, neuroradiologist, myocardial infarction, drug manufacturer, relieves symptoms, institutional care, medical treatment, ventricular arrhythmia, human anatomy, dental plates, gaping wounds, circumferential growth, allergy medication, cushioning shocks, adjoining vertebrae, rounded projections, sliding movements, thickened edges, peculiar formations, thoracic portions, shoulder girdle, sternoclavicular joints, and expanding portions. All right. Now, my next drill is going to be sentences with consonant compounds. Hold on one second. I've got a bunch of little stickies here for lower speeds, high speeds, and mid speeds. I had to find my ones for mid speeds. All right, so this is going to be initial consonants that start with TH. Here we go. Thank you for your interest. That is the way it goes with them. They live in thatch huts. I wish the ice and snow would thaw. Live theater is very interesting. The class is interested in theatrics. How do I love thee? Let me count the ways. Who discovered the theft? You owe them your attention. It was a happy theme. The game ended then and there. Students of theology go to school for years. I hope your theorem is correct. Most of the questions were very theoretical. According to that theory, we are wrong. A therapist gives the therapy. Do you believe in theosophy? There are lots of thick branches. In Alaska, you need thermal clothing. That thermometer must be wrong. I've got one more for you. This is going to be initial consonants KL. We climbed to where the climate was cold. Clementine was a clerk for the cleric. Cleopatra clung to the clergyman. Cleaver, Clevelanders live in Cleveland. The clue was the client's climax. If you hear a click, jump off the cliff. They were clinging to the clinch in the clinic. It was a clinical class in the cliffs. Clip the clipboard to the clipper. We claimed the clinkers from Cleveland. She hid the clock under her cloak. He was clobbered in the cloakroom. The clodhopper threw clods at us. Cloggers clipped away on their clog dance. We were close to the claimant. The clouds looked like clover. The clubber clubbed the cluster. Your clutch is cluttered with clumps. The clumsy Clydesdale was a clue. 2 clowns were in the club. All right, common phrases. Here we go. Would recall, you recalled, received in evidence. Can he recollect? Can I recollect? Can recollect? Can you recollect? Could have recollected, could recollect. Did he recollect? Did I recollect? Did you recollect? Do I recollect? Do you recollect? Does he recollect? Had recollected, have recollected. He recollected, he recollects. I can't recollect, I didn't recollect, I don't recollect. If he recollects, if I recollect. Would have recalled, will recall. Which I recalled, which I recall. Which he recalls, which he recalled. Whether you recall, whether you recalled. Whether or not I recalled. Whether or not you recall. Whether or not you recalled. Whether or not he recalls. Whether or not he recalled. Whether I recall, whether I recalled. Whether you recalled, whether he recalled. Whether I recall. Where you recall, where I recalled, where I recall, where he recalls, where he recalled, when you recalled. All right. These are going to be final NK endings. So you don't have we have to flag it so we don't have a conflict with NG. Okay, so here are the words first, and then I'll give you the sentences, okay? The ink to drink, the tank to honk, the rink to wink, to slink, the bank to clank, the brink, the plank to shrink, the rank, the fink, a crank, a link, the sink, a bank. Did you ink the press? He drank on the job. The gun fired blanks. Where is the junk? The tank was empty. Who robbed the bank? He said it was a prank. Don't pull rank on me. Being drunk is no defense. I spilled the ink. Use wide planks. Fill up the tank. The ink was hardly dry. That's a new wrinkle. hunt for the missing link, raise the anchor, close your trunk, honk your horn. He drives a tanker. He's a lanky youth. It looks as if he's sunk. Meet me at the skating rink. What rank do you hold? Get a drink for me. Put it in the sink. It's a ranking privilege. Use ink for the signature. He winks at violations. He's an old crank. What is the link? The witness wore pink. It was a punk kid. The rink is closed. He walked the plank. You'll sink or swim. It's a honky tonk. My uncle testified. It was a bank fraud. It was a rank affair. He testified frankly. The witness had spunk. My uncle is a banker. He plunked it down. It created a stink. It sank out of sight. I'm so bummed. Upstairs I had an article that I went through and, read through it, and I marked it, got it all ready, and then I forgot it. I'm so bummed about that. Darn it. Oh well, it's okay. All right, so let's do some Tangle Tamers. All right. I just can't believe I forgot that. Darn it. Oh well, I'll read it tomorrow. All right, here we go. And these are like legal phrases that are Tangle Tamers, okay? Here we go. Presumption of innocence. Establish such proof. Statements of the witnesses. The jury is satisfied. Full, fair, and impartial jury. Verdict of acquittal. Credibility of the witnesses. Fair and just verdict. Recover upon the contention. Guilty of negligence. Based solely upon. Recall this charge. Degree of proof. Burden to establish. Interest, bias, or prejudice. Reasonable, careful person. In this regard. Ordinarily prudent person. Absolutely no presumption. Instructions of the law. In the event that. Common law negligence. No affirmative defense. Direct unbroken sequence. More likely so than not so. Duties of citizenship. Admissible on the facts. Rule on admissibility. Performance of your duty. Benefit of the doubt. Innocent until proven guilty. Physical evidence. Exclude from consideration. Arguments of counsel. Contributorily negligent. And reaching your verdict. All right. I've got some names. They're proper names. They're actually speakers that addressed a certain group of congressmen on the subjects that I'm going to say. All right, so I'm going to spell their last name and then give you the subject. Mr. Davidson Murtha, M-U-R-T-H-A, the Johnstown flood. Mr. Eric Schuster, S-H-U-S-T-E-R, campaign tricks. Mr. Mendel Davis, D-A-V-I-S, use of CB radios. Mr. Floyd B. Courtier, C-O-U-R-T-E-R, arbitrary bureaucracy and the Presidential Insurance Company. Mr. William Gingrich, G-I-N-G-R-I-C-H, federal income tax reduction. Mr. Radford Zablocki, Z-A-B-L-O-C-K-I, Conference for Women, United Nations Mid-Decade. Mr. Brian Wolf, W-O-L-F-F, Wolf Amendments. Mr. Edward Broomfield, BROOMFIELD, United Nations Support. Mrs. Bryn Okar, OAKAR, appointment of a U.S. delegate to the Conference on Women. And Mr. Victor Witten, WHITTON, Agricultural Rural Development. All right. Let's do some names and addresses, and then we'll move into literary. Here we go. Stephen Schaller, SCHALLER, 305 East 4th Street, Waterloo, Illinois, 62298. Mrs. Janet L. King, KING. Stacola High School, Route 2, Box 114, Robbinsville, North Carolina, 92871. Mrs. Yvette Bonaparte, BONAPART, 13705 Greenbrier Drive, Dale City, Oregon, 97832. Rachel B. Berry, BARRY, P.O. Box 1167, San Francisco, California, 96550. Gigi L. Kadik, CADICK, 3316 Hackney Drive, Kettering, Ohio, 45220. Kimberly A. Burden, BURDEN, Route 1, Box 634, Scottsville, Colorado, 84590. H.J. Croce, CROSE, 65 Willow Spring Road, Baltimore, Maryland, 21252. Shelley M. Hill, HILL, Route 3, Box 42B, Taylorville, Illinois, 62568. Mr. Paul Schultz, SCHULTZ, Blue Earth County High School. Offices in Mikado, Minnesota, 56001. Right. Now, I forgot about this one. It's just a word preview list, okay? This is the last thing we'll do before we start our literary. Here we go. So we have accommodate, factual, graduate, accommodation, admissibility, graduation, innocence, institutions, agricultural, intimated, allocated, apology, intolerable, jurisprudence, arbitrary, assistance, liberalized, medication, asthma, orthodontic, austerity, colleagues, prejudice, conferees, commendation, prerogative, prescriptive, probative, conscientious, controversial, proposals, credibility, reasserts, seizures, deliberate, subsistence, demeanor, dispensed, tuition, dissuade, typical, undeniably, eliminate, epilepsy, universities, erroneous, version, zealously, and extravagant. All right. Now, the first thing that I'm going to give you is called an invitee. Okay, it's only about 2 paragraphs long, and I'm going to start at 120, and I will work my way to, I'll work my way to 140 on this one, okay? Here we go. Let me just state this. All right. Here we go. The first issue for your determination on the claim of the plaintiffs is whether, at the time and place of the indictment complained of, the plaintiffs were invitees on the premises owned by or in the possession of the county. A person is an invitee on land or premises owned by or in the possession of another when he or she is invited or permitted to enter or remain there for a purpose directly or indirectly connected with the business of the owner or possessor, or connected with business dealings between the visitor and the owner or possessor, as distinguished from benefit or convenience merely to the visitor. Such a person remains an invitee as long as he or she uses the premises in the customary manner or in a manner which the owner or possessor of the premises might reasonably have expected, and at a place where the visitor was invited or where he or she was permitted to be, or where he or she might reasonably have been expected by the owner or the possessor. All right. Now, this one is on insanity. Here we go. I'm going to start this one at 140 and move my way to 160, okay? Here we go. Insanity will excuse somebody from the responsibility of a criminal act is defined in the law as being such a state of mind that a person therein is so far from being in contact with reality that he or she does not know the difference between right and wrong, and he or she does not appreciate or know the nature or quality of his or her acts. If his or her mental condition is anything other than that or greater than that, as far as progressing towards the state of awareness or knowing the right from the wrong, he or she is not insane as far as the criminal law is concerned. In regards to insanity in the criminal law, any intention by the defendant in regards to being relieved of criminal responsibility by virtue of insanity is an affirmative defense. This means that the defendant must make out this contention by the preponderance of the evidence, not beyond a reasonable doubt, but by the preponderance or greater weight of the evidence. Okay. I'm going to read you some literary on capital crime. Again, I'm going to start this one at 140. I'll work my way to 160, okay? All right. Here we go. The U.S. Supreme Court, having virtually wiped out the death penalty some years ago, has subsequently restructured the penalty within limits and continues to refine its guidelines. In a landmark decision, Furman versus Georgia, the High Court held unconstitutional Georgia statute, which gave the jury complete and unguided discretion to impose the death penalty or not as it saw fit. That decision stopped capital punishment in its tracks while state legislators struggled to devise laws to comply. Several states subsequently enacted statutes withdrawing any discretion on the jury's part by making the death penalty mandatory upon a finding of guilty. Actual experience with laws like that indicated that many juries were acquitting clearly guilty defendants if the jurors felt that the defendant did not deserve to die for his crime. In a North Carolina case, the court held that this was as bad as the situation that existed before the Furman decision. The Supreme Court further defined its position on June 20th in a case arising in Alabama. Alone among the states that have capital punishment statutes, Alabama's law provides that a jury in a capital case cannot convict a defendant of an offense similar to, but lesser than the one charged. The defendant in the case that reached the court admitted on the stand that he and an accomplice had participated in a robbery of an 80-year-old man. He denied, however, that he had killed the man or intended to. He said he had seized the victim and was about to bind him with a rope when his accomplice unexpectedly hit the man and killed him. Under Alabama law, he could have been charged under these circumstances with felony murder, which is a lesser offense than the one with which he was charged, robbery, intentional killing, a capital crime. The trial judge was prohibited by law from instructing the jury of the lesser offense. He was required to tell the panel that they could find the man guilty of robbery with intent to kill and give him the death penalty or free him completely. A third option, of course, was to arrive at no verdict, thus creating a mistrial. The defendant was convicted and sentenced to die, thus setting up the appeal. Under common law and under many former state statutes, juries were permitted to find a defendant guilty of less severe offense. This sensible safeguard remains in federal law and in the laws of most states that permit capital punishment. In the past, for example, the South Carolina Supreme Court set aside a death penalty and sent the case back for resentencing when the trial judge failed to instruct the jury that it could recommend a life sentence rather than execution. The Alabama statute does not include this alternative, and the Supreme Court properly shot it down. Justice John Stevens wrote that if the evidence unquestionably establishes that the defendant is guilty of a serious violent offense, but leaves some doubt that the death penalty is appropriate, failure to give the jury the third option of convicting on a lesser offense would seem inevitably to enhance the risk of an unwarranted conviction. Such a risk cannot be tolerated in a case in which the defendant's life is at stake. While this ruling has limited application at present, it will serve to guide states that may wish to impose a death penalty or amend present statutes. It is thus a potentially valuable addition to the law. All right, how are we doing on time? Oh, good, we're doing great. Okay, I'm going to give you one more. This is on product liability. I'm going to read this whole thing at 160, okay? Product liability. All right, here we go. In recent months came the news that a jury in a federal court in Oklahoma City had awarded the estate of the late Karen Silkwood $505,000 in actual damages and $10 million in punitive damages. The suit alleged negligence on the part of the Kerr McGee Corporation in the operation of a nuclear facility where the woman worked as a lab technician. The award was made despite defense testimony that the plant had been operated in compliance with the government safety standards, and despite the testimony that the woman might have contributed to the contamination she suffered. Incidentally, she did not die of whatever exposure she suffered. She died in an automobile accident. We have no knowledge of the facts in that case, other than those reported in the press, but we cite it as an indication of how willing juries are inclined these days to make huge awards to individuals who have brought negligence suits against large companies supposedly backed by rich insurance companies. As a further example of the prevailing mood, we note that one of the Silkwood lawyers urged individuals living around the damaged 3 Mile Island nuclear plant in Pennsylvania to go gangbusters in filing lawsuits. No doubt he would be happy to go there and take some cases on contingency fees, which means he would get 1/3 or more of the awards if he wins. A number of examples of the nation's litigious trends have surfaced here in South Carolina in the product liability fields, to cite only one area of mounting concern. The Insurance Information Institute reports that Little South Carolina had the 6th highest number of lawsuits based on product-related claims filed in the federal courts during the fiscal year 2008. Most of them were concerned manufactured products which were involved in personal injuries at some time subsequent to the sale. A manufacturer's liability for a defective product may last for many years, even if the product was altered by the user or not used for its original purposes. The trend is to fix liability even if the manufacturer complied with all safety standards and employed all of the technology available at the time of manufacturing. Failure to warn of the potential hazards can cost a company. Farberg Incorporated, for example, argued that it could not have reasonably been expected to foresee that a teenager intent on scenting a candle would pour its perfume on an open flame, causing it to ignite and burn another teenager's neck. Farberg nonetheless had to pay $27,000. One obvious result of this trend is soaring insurance rates, which are particularly painful to small companies. This can chill product development and cost jobs. We know of one South Carolina-based manufacturer that decided not to make a new line of ladders when it learned how much product liability insurance would cost. And of course, high premiums are running up consumer costs. Efforts are being made in the South Carolina House of Representatives to get actions on a bill placing certain limits on product liability, including that length of time after manufacturing that the liability continues. About 1/3 of the states have passed legislation in this area to curb the excess in the courts. Plaintiffs' attorneys, of course, do not like such bills, and they have a great deal of power in most state legislators. But a balanced bill that offers an adequate protection to injured parties without imposing undue cost on manufacturers and the general public is certainly needed in this suit-happy society. I have noticed recently that, and I don't know if you've noticed this on TV, but it just seems like there's a lot of like group lawsuits, like, have you ever taken this? You know, you could be part of this lawsuit. And I'm sure some of it is, you know, is accounted for, you know, like people have good excuse to sue, but it just seems like lately it's been really bad. It's pretty crazy. I think the other night we saw like 3 different ones. Okay. Let's see here. We've been working on this Q&A, and looks like plaintiff, starting out with plaintiff, but the court and defense jumps in. So I'm going to start at 120 and I'm going to work my way to 160, okay? All right, here we go. Well, I don't know that it would. You know, one thing, maybe she could help us find it. If not, we can find out from the bank that it was drawn on, get a copy of it from the bank. 3, if that doesn't work, then we can take depositions, perhaps, not from his mom, because she's not going to be able to respond too much in a deposition, I would think, with her health. It's supposed to improve the voice. The vocal cords are supposed to improve, but it's been now 3 months and she's still at a whisper. But his sister, both sisters were present when this transaction was discussed. Well, she went to both for when my father died. All this took place afterwards. So she just talked to them regarding circumstances and what should be done. As far as the money and whether she should let him renew the loan or what. So if we had to, when was the case filed? We made a filing April 25th. This is the first date set. Okay, so it's about 4 months old or a little less than 4 months old. We started out with a settlement proposal that was never responded to. We have an interest in getting this thing over to, Your Honor. We are trying to keep the cost down. As far as sitting around today, I advised Ms. Hendrickson that I was sitting today. Here's the concern that I have. Even if I continue it 1 month, for example, your discovery cutoff is what? 30 days prior to trial? So you wouldn't have any opportunity to do any discovery. But the court could waive that, could allow us discovery until that time. We cooperated. She submitted. Wouldn't it be cheaper just to have the sister come out here for trial as opposed to your going back to the East Coast and paying an attorney to take a deposition? You know. Well, it may be. We've looked into it. And I think we can make arrangements from our side anyway to have the deposition taken. I don't know about flying your sister out here and inconveniencing her as far as for her to testify. I have 2 sisters. Maybe it would be better if we have her here just for the trial as opposed to the deposition. What harm are you going to be occasioned if we continue it, say, a month or 6 weeks? How are you going to be prejudiced? Are you suggesting, Your Honor, in order for me to determine that, are you suggesting there would be another mandatory settlement conference? No, there doesn't have to be. Just continue it for trial. Okay. We'd be amendable to it either way, Your Honor. I think once we get this stuff, if it shows, if we can't come up with some documentary evidence, then it's something that we're probably just going to have to submit. And we'd have to have the trial on that. But if we do come up with the documentary evidence, I hope counsel would recognize that and say, okay, this is what it is, and that would resolve it. You want a settlement conference or not? Well, my client cannot afford to engage in this kind of litigation. The prejudice to my client is, first of all, that she has to continue to miss work, and she can't afford that. And I believe here that it's the petitioner's responsibility to, whatever you're going to have, you didn't settle it, right? You need a trial date. So she's going to have to take off for trial one day or another. I'm just wondering how you would be prejudiced by having a different date for trial. Well, if there's not a second mandatory settlement conference, we wouldn't be prejudiced in that way. However, I do feel by this additional time, what we're doing is giving counsel an opportunity to create evidence. And I am really concerned about this. This loan, this alleged loan, took place, it was really a gift, took place back in 2006. And counsel has talked about even the terms of this note. But there's absolutely no information anywhere written. Well, we don't know. He says there is, and he believes there is. Okay, well, I believe, Your Honor, that 4 months is an adequate amount of time for him to have gotten his evidence together, especially when we answered his petition immediately. And then he's the one who set it for trial. We did it, and my client cannot afford to fly back and get depositions or conduct, a major discovery campaign on a $123,000 equity in the home. Well, I suppose when you bought the last home, how long ago was it you bought the last home? I believe you purchased it in 2006. I know that the first time was in 06. When was that home sold? In May of 08. May of 08, 3 years ago. It might be that a payment was made in the escrow. How was it? You said that you paid your mother $20,000, was it? We owed her mother money, which we paid. We owed hospital bills, which we paid. We wrote my mom a check out, which we paid. And I'm assuming that all of this went out of the checking account, I assume. What bank did you have at that time? CalFed, CalFirst. When you bought the second home? No, before we bought the second home. Wells Fargo, no. Security Pacific, I'm sorry. That was when we bought this home. I'm saying back in 06. We're talking about the $20,000 check that you paid to your mom for the interest. That would have been in 08. That was when we sold in 08. When you sold in 08, what account would that have been out of? I don't remember what account. I guess it was CalFirst or CalFed, one of those. CalFed. So we can get that. He does not have that. The respondent has those checks. In any event, I suppose we're going to have to get those from the bank. I think that would be in case. Do you know the bank? He said it was CalFed. I assume it was. There were several banks around that period of time, I believe. Is that not correct, Mrs. Netter? In your transition from Garden Grove or wherever it was to here? I'm trying to remember. But in any event, it was a regular checking account that you were using. Is that correct? Uh-huh. And the $20,000, the source of that was when you sold the house in Orange County. Is that correct? So you put some money down and you had some money left over from the sale. We had $140,000 from the sale of the house. How much went down? 10, close to $100,000 plus some costs. So you had about $120,000 to $120,000 plus to pay different expenses with and repay the loans and that sort of thing. So you're currently set for trial on the 13th? No, the 26th. The 26th. Okay. That's another day that I'm scheduled to be down in Department F3. So that day is not convenient anyway. Well, we're now at the 12th, right? Today is the 12th. So you would want to continue to how much? I think 6 weeks would probably give us enough time. 6 weeks from today or 6 weeks from today would do it. Don't you think we can get the records back from the bank records back from there? Either that or a deposition or Your Honor, if you are going to consider their request for a continuance, I would request that as part of that order, that petitioner be required to provide the documents responsive to our production request. Your Honor, we gave her a package. Let me know what you don't have that you requested. There's some in that package. What day would be better for you, the 23rd or the 30th of September? Your Honor, just in case, I think the 30th would be better for my calendar. I'm sorry, what are the dates that you suggested? The 23rd or 30th of September? Yes, the 23rd would be better. The 30th would be better for you. The 30th would be better. Can we agree on anything? The only reason I say that is that right now we are anticipating Commissioner Reeks would be back on the 13th. If she's not back then, and I'm still filling in, I'll be sitting down there on the 23rd. I don't want to happen again what happened today. And I have a trial on the 1st of October. On the 1st of October? Yes, which is the day after the Monday. It's a jury trial, and that's why I've selected the 23rd of September. Any other date during that week is fine too. I don't know if the court was, all right, the 24th, 25th, 26th. Those are fine with me. The 26th, I've got a trial, so I wouldn't want to double up on that. 24th, 25th. The 24th or the 25th would be okay. The 24th, Tuesday, better than Wednesday? Uh-huh. Okay, September 24th, 8 o'clock in Department F1. Okay, and then let him know what it is you want that he hasn't furnished to you, or tell me. He hasn't furnished us with any income tax records, Your Honor. That's really critical. Okay, do you have your income tax returns? Do you have your income tax returns yet? They're in the car. They're in the car. We'll get them to you today. You couldn't find 08. Was that right? I have 09 and 10. 09 and 10. Who did them in 08? Do you know? We did them jointly in 08. We did them jointly in 09. We did them separately in 2010. But you didn't keep a copy of the return? I cannot find it. I can find 06, 07. I can't find 08. I've got 09. You can, I guess, get a copy from the IRS. She can do that, Your Honor. Either one of them. It's not going to tell us anything anyway. Well, if it shows an interest in expense, that's true on that. It might be support for your contention that you made a payment on a loan. That's true. What else, counsel? We haven't obtained a full mortgage statement. It's equally obtainable. Your Honor, this is some of the stuff too. She wants us to do her legwork for her. She can go down to the mortgage company and see how much she has been paid or how much has been paid on this loan and get that. She'd rather send us off running, scurrying to get it. What's the point of? Your Honor, my client is not in the home. She doesn't have any of the documents or the records, and Mr. Netter is the one making the payments. You don't have to go get it for her if it's equally available to her, but if you have it in your possession, like any kind of a receipt book or online, something like that, can you print it out and furnish her with it? Well, Your Honor, she wants 3 years of checks from the time we moved into the house, and I don't know if I can come up with 3 years worth of checks. I supplied the numbers. I supplied a statement to her today showing her what these statements were and the buyout, and I supplied her, since she moved out in June, all of the canceled checks. She can just call to find out whether it's current or not current, or how much was paid. It's equally obtainable. That's not quite accurate, Your Honor. The payments on the house. You want the payments on the house for 3 years? No, we've not asked for the payments on the house for 3 years. Not at all. We've asked for the 2015 mortgage statement on the first and the second trust deeds on the house on Candlebrush Court. If you have those, if you have them in your possession, then make a copy of it and give it to her. Everything I have has been supplied to counsel. We've also asked for copies of the documents that support the bank card, the MasterCard, a community property debt, and we have not received any document other than billing statements that have occurred outside during the separation period only. That's not, Your Honor, I supplied statements starting in September, and it is the respondent's contention that we separated in October. So all of the billing statements prior to separation has been supplied. Everything that I have had has been supplied to her. All right, so I'm going to switch transcripts. You can just feel the tension in that case. Okay. This is going to be, I'm going to read this at 160. Okay. All right. How are we doing on time? 52. Okay. The court calls number 26, the Smith Records. Pam Maloff on behalf of the department and David Cundy on behalf of Lauren and Evan. The appearance of Lauren be waived. Debbie Rosenquist for the mother who is present, and Raymond Jandra for the father who is present, courtesy of the Sheriff's Department. We are here for an ongoing contested permanency planning hearing, and the next door proceedings is that Mr. Cundy asked to call the paternal grandmother, Mrs. Smith. Counsel, would you ask Ms. Smith to come in, please? Yes, Your Honor. If you'll remain standing, please, to be sworn. I do. Please be seated. Please state and spell your name for the court's record. My name is Joan Smith. Joan, Joan, Smith, Smith. Thank you, Mr. Cundy. Thank you. Good morning, Ms. Smith. Good morning. Ms. Smith, is it true that you sat in on the proceeding when the social workers, Ms. Simpson, testified, correct? Yes. Okay, and you were also able to hear during the testimony certain information pertaining to the issue of the mother hitting Evan. Is that correct? Yes. Now, what's the relationship to Lauren and Evan? Grandmother. And do you have contact with Lauren and Evan? Yes, I do. And can't you explain the type of contact you've had with them? Every other week they spend the night at my house, and the last time I had them, which has been about 3 weeks ago, I had them for 4 days. How long have you been visiting with Lauren and Evan? Ever since they left my house, I never got out of contact with them. And how many months or years ago would that be approximately? A year. And prior to that, they were placed with you for a short while? Yes, they were. Now, when did you first become aware of a statement made by Lauren that her mother hit Evan? When I first started keeping the kids, the second time that I had ever kept them, that's when I heard it from the kids. And where you heard from the children? Yes, but I also heard it from the foster parents before, but I never did talk at them about it because I never did believe it. And approximately when was this that you that the foster parents told you about the hitting incidents? I can't recall the date, but it was when Tylen started having visits by herself with him. Now, how soon after the foster mother told you that Lauren told her that her mother hit Evan, did you actually hear something from the children? The second time that I ever kept the kids, that's when I heard it. Okay, and when you mentioned you heard something from the children, would that be from both children? Yes. You want me to specifically say? If you can, yes. Okay, the first time I heard, the first time I kept the kids, I put the kids in the bed. I turned the light to go out. I kissed them goodnight. And Lauren started saying, Grandma, sweetie, Grandma, sweetie. They call me sweetie. My name is Joan, but they call me sweetie. So I went back in and she said, Lauren slapped, put Mr. in the garage and turned the light off and slapped him. And I said, who told you that? And she said, Mayla told her that. Okay, so I took them up out of the bed and I said, I can't believe this here. And so that's when she said it again. She said, who told you that? And then she said, Karen, Mama Karen. And that's when I said, I don't believe this here. And I got on the phone and I called a couple of my friends. I said, listen at this here. I said, someone is planting this in these kids. They've been programmed like that. I didn't pay no more attention. I let them play for a while. And so the next time they came over, it happened again. And then Mr. said, I was doing my other grandbaby's hair. Mr. walked up to me and said, Grandma, sweetie, Lisa slapped me. And he, used his hand. And he don't even know who Lisa is. That's why I know that this was a lie. And it went after that. It went on and on. They would be playing. I would be cooking or washing dishes. They would come in and it was like they was programmed. I never did believe it. That's why I never did bring it up with the foster parents. I didn't want to talk about it. And when I was here and it came up, I was back there. I was raising my hand. I wanted to say something then when I was in the back. That's what I wanted to say, All right, so we'll stop there and do some read back. Okay. All right, first time we'll be at 160 and then we'll do it again at 140, 120. Okay, and looks like plaintiff is questioning. Here we go. Have you ever had any conversations with Brian Mason? Yes. When did you talk to Brian Mason? While we both worked for Tilton. Have you ever talked to him since? No. Did you ever talk to him while you were at Tilton about leaving Tilton? No. Did you ever tell him that you were going to leave Tilton and join Victory? No, sir. While you were at Tilton, did you ever tell anybody that you were leaving to work for Victory other than your notice? No, sir. Have you ever at any time told anybody to your knowledge that Victory knew everything there was to know about Tilton? No, sir. May I correct that statement? Yes. I recall someone discussing something about Victory, knowing something about Tilton, and it referred to a time when Victory went over Tilton's books, as I understand it, in a proposed merger of the two companies. I don't even recall who made the statement or when it was. Were you an employee of Tilton when Victory did go over the books of Tilton? I believe so. You say there was a proposed merger? This is the rumor I have been told. Who told you that? I believe it was Mitchell Grant. Have you been told anything else with regard to that proposed merger? No, sir. Do you know anything else about it? No, sir. By rumor or otherwise? No, sir. All right, so we'll do it again at 1:40. Here we go. Have you ever had any conversations with Brian Mason? Yes. When did you talk to Brian Mason? While we both worked for Tilton. Have you ever talked to him since? No. Did you ever talk to him while you were at Tilton about leaving Tilton? No. Did you ever tell him that you were going to leave Tilton and join Victory? No, sir. While you were at Tilton, did you ever tell anybody that you were leaving to work for Victory other than your notice? No, sir. Have you ever at any time told anybody, to your knowledge, that Victory knew everything there was to know about Tilton? No, sir. May I correct that statement? Yes. I recall someone discussing something about Victory knowing something about Tilton, and it referred to a time when Victory went over Tilton's books, as I understand it, in a proposed merger of the two companies. I don't even recall who made the statement or when it was. Were you an employee of Tilton when Victory did go over the books of Tilton? I believe so. You say there was a proposed merger? This is the rumor I have been told. Who told you that? I believe it was Mitchell Grant. Have you been told anything else with regard to that proposed merger? No, sir. Do you know anything else about it? No, sir. By rumor or otherwise? No, sir. All right. Last time at 1:20. Here we go. Have you ever had any conversations with Brian Mason? Yes. When did you talk to Brian Mason? While we both worked for Tilton. Have you ever talked to him since? No. Did you ever talk to him while you were at Tilton about leaving Tilton? No. Did you ever tell him that you were going to leave Tilton and join Victory? No, sir. While you were at Tilton, did you ever tell anybody that you were leaving to work for Victory other than your notice? No, sir. Have you ever at any time told anybody, to your knowledge, that Victory knew everything there was to know about Tilton? No, sir. May I correct that statement? Yes. I recall someone discussing something about Victory knowing something about Tilton, and it referred to a time when Victory went over Tilton's books, as I understand it, in a proposed merger of the two companies. I don't even recall who made the statement or when it was. Were you an employee of Tilton when Victory did go over the books of Tilton? I believe so. You say there was a proposed merger? This is the rumor I have been told. Who told you that? I believe it was Mitchell Grant. Have you been told anything else with regard to that proposed merger? No, sir. Do you know anything else about it? No, sir. By rumor or otherwise? No, sir. All right, so we'll go ahead and read that back. Just let me know when you've found your spot.
Okay.
Found it? Okay, if you want, I can take the first question and answer. Here we go.
Sure.
Okay. Have you ever had any conversations with Brian Mason? Answer, yes.
Question, when did you talk to Brian Mason? Answer, while we both worked for Tilton.
Question, have you ever talked to him since? Answer, no.
Question, did you ever talk to him while you were at Tilton about leaving Tilton? Answer, no.
Question, did you ever tell him that you were going to leave Tilton and join Victory? Answer, no, sir.
Question, while you were at Tilton, did you ever tell anybody that you were leaving to work for Victory other than your notice? Answer, no, sir.
Question, have you ever at any time told anybody, to your knowledge, that Victory knew everything there was to know about Tilton? Answer, no, sir. May I correct that statement?
Question, yes. Answer, I recall someone discussing something about Victory knowing something about Tilton, and it referred to a time when Victory went over Tilton's books, as I understand it, in a proposed merger of the two companies. I don't even recall who made the statement or when it was.
Question, were you an employee of Tilton when Victory did go over the books of Tilton? Answer, I believe so.
Question, you say there was a proposed merger? Answer, this is the rumor I have been told.
Question, who told you that? Answer, I believe it was Mitchell Grant.
Question, have you been told anything else with regard to that proposed merger? Answer, no, sir.
Question, do you know anything else about it? Answer, no, sir.
Question, by rumor or otherwise? Answer, no, sir.
Great job. Awesome job. All right. Well, so I did want to ask you, because I know you're always in either the mid and the high speeds class. Robert's thinking about doing a little bit of changing with some of the classes. He's thinking about having me do more of the theory recordings and then changing the live classes instead of an hour to an hour and a half, and having turning two of them at night, like late at night, and then keeping the one. So Friday, we were thinking about doing lower speeds on Monday from, let's see, what time did we say? That would be from, and this could change, but maybe from 8:30 to 10, and then that would be lower speeds. And then Tuesday night, no, I'm sorry. Wednesday, possibly doing 9 to 10:30, because it would be an hour and a half as opposed to an hour. That would be the mid speeds. And then Friday, keeping the upper speeds on Friday from 9 to 10:30, keeping the upper speeds Friday morning. And there's two things that he's trying to target here. Maybe if we have like 2 later classes at night, then more people could attend, because they've got, they hopefully by then they would have their kids settled, dinner done, and also cutting down to 1 class instead of 2 per week, so that I can do more of the recordings for the theory. But he did say to make sure and get your thoughts on that, because you are always in the live class. And he said, we've got a lot of recorded live classes, that are recorded, but, he wanted to get your take on that.
So you're saying PM? Those times you gave me are PM?
Yeah. So lower doesn't really affect you because, it's
Yeah.
lower, but that would be Monday, probably around, it would be about 8:30 to 10. Wednesday would be the mid speeds. Wednesday evening from 9 to 10:30, which I know you're 3 hours ahead of us. So that would be really late. 2 hours.
Still pretty late, but 2 hours.
2 hours. Okay. That would be the mid speeds Wednesday, 9 to 10:30. And then Friday, we would keep the morning class and it would be 9 in the morning to 10:30. It would go until 10:30 as opposed to 10. And then, so just having the two, the one live class per, lower, mid, and higher speeds as opposed to the two. Does that make sense?
Mm-hmm.
So what are your thoughts on that?
I mean,
Like, do you feel like there's enough recorded material that you can go in and watch that, and as well as doing the one live class?
yeah, I mean, there's a lot of material. The live class just personally motivates me a little bit more. I don't know why. It just like, but for me, as long as I can go to the high speed class, I'm kind of like, okay, like I kind of do this as my trail class, so to speak,
Right. The mids, more of your trail speeds. Yeah.
Yeah. So, I mean, the Friday class isn't really changing. So,
Right. Yeah, that would stay the same. And instead of 9 to 10, it would be 9 to 10:30.
yeah, I mean, that works for me.
Okay. Then let me talk to him and see what he says. Cause he just said, mention it to her in class and see what she says. And again, we're trying to see what works. And, I don't
Yeah.
know if we would get more if we did it at late at night. It's hard to say, It's kind of like if we did it early in the morning, would we hit more people or would they be going to work? So they would, it's really hard to gauge that.
Yeah, it is. Yeah, I mean, you can't really, for the late classes, you can't really go by me because that's like I'm already in bed by that time.
Yeah.
So,
Yeah.
but I'm here. So that, if that works for the people in California, then.
Well, let me talk to him and see what he says. Because at least we would keep the light or the high speed on Friday morning. But, he's thinking about having it go down to just one instead of two because there's so much recorded material. But let me just talk. I'll see what he says.
I mean, for me, even if you move to be honest, if you move the high speed to late at night, I know you're not saying that, but if you were to, I'd probably stay up because it's just a priority for me. So, I mean, I don't care, but I mean, I love coming to the live classes.
You do? Okay.
So, I mean, I would make an effort to come and stay up late. Like that would be fine for me.
Okay.
So maybe if you could get more people, that would be a good move. But
yeah,
I mean, you probably don't want to do a class at 9 p.m. on Friday night.
yeah.
You probably wouldn't get people on a Friday night, to be honest.
That's what I was thinking too. It's their weekend and they're, most people do something on a Friday night. So
yeah, we usually do. So if it were on Friday night, that probably wouldn't be the best, but.
Okay.
Yeah.
Well, let me talk to him and then see. I'll definitely, keep you posted.
My feedback is I want more live classes, Jill. Not that.
He'll be watching this, so.
But that's just me. No, I'm good with whatever. I'll follow you wherever you go.
Oh, okay. I'll talk to Robert and I'll definitely get back to you. Okay.
Okay.
All right. Yeah. Don't stress. We'll work something out. So.
I probably won't be here for much longer, to be
I
honest with you.
know.
So
I know. I
keep that
know.
in mind too.
I am. I'm excited for you though. I really am.
Yeah.
So, okay. All right. Well, I'll keep you
All right.
posted. Okay.
Okay. Sounds good.
All right.
All
Bye.
right. Bye.